Maybe now?
Yeah, I can answer that question based on that video.
Okay. Did you talk to anybody about your injuries?
I told the sergeant that I kicked in the front.
You told him? Okay. At what point did you tell him that?
He turned around.
She turned around? Okay. So here we are at the, just about where the prosecutor left off at the 4-minute mark. Still, we have not seen any from this angle, right? There's other angles.
Objection, is that a question?
No, it wasn't a question.
It was not.
I'm not even paying attention to it. It's extraneous, so I understand.
So here we are. Still, you have not said anything to Sergeant Gibbs, correct?
I mean, when the camera hit the ground, I didn't hear what was going on at that point.
Okay.
So
What you're watching right now is a courtroom collision between a self-represented defendant and multiple officers over a late-night encounter that spiraled into an arrest for resisting and obstructing. The defense is clearly pushing one central theme, that this detention and search lack justification. The prosecution, on the other hand, is focused on noncompliance and obstruction during a police response to a reported fight in progress. And here's what makes this tense. The defendant has attempted to challenge officer credibility directly, even introducing video and transcript evidence to suggest inconsistencies. The judge is firmly controlling the courtroom, sustaining objections, and drawing strict procedural lines. The real question becomes this: was this a lawful detention tied to a legitimate investigation, or did this escalate unnecessarily?
Did you get home the wife? Oh, see that phone? Yes. What's your wife's name? Miranda.
you're home, right? If your wife and you got a key to get in the house,
So you were planning on giving him a ride home?
yes, we're gonna give him a courtesy ride home.
So you did not suspect him of any crime. You were going to actually do him a gesture.
Relevance, Your Honor.
Sustained.
Clarifying.
Yes.
You do have a key to get in the house, can you show it to me?
Yes.
Can you show me the key?
Yeah. So yeah, that's not just a move. We have HVA just high end top. So I don't know. High end top. High end top.
This is the burger.
Oh, yes, he is. So, we'll charge him one interfering. So we charge all the means out, whatever, reasonable interfering. You don't want there. Did he?
Man, kick him.
So real quick, and I'll cut it off right there. But at that time, it is your understanding that I'm only on arrest for, what was that? He said R&O?
Yes, resisting and obstruction.
Resisting and obstruction. Back to why I didn't walk away the 5 feet. Yep, thank you. Okay, so at this time, he's what would you call it? He's basically reciting the charges that he's what would you call that?
Objection, Your Honor. Relevance.
Sustained.
Okay. From my understanding, and I believe it is yours as well, correct me if I'm wrong, is this the point in time where you informed Sergeant Gibbs that you were injured?
I told him I was kicked.
Okay, you told him you were kicked. Let me back it up. So now this is the 7-minute mark, a good 5 minutes after my arrest.
He kicked me in the nuts, bro.
He kicked you?
Why you think I got with him? I wasn't trying to do it.
Oh, I didn't know you. Right there. So,
Is it accurate to say that we can't define at which point you were kicked?
Your Honor, I'm gonna, never mind. I'll just-
Is that true?
Based on the angle of the video from my body cam, I can't tell you exactly when it happened. I know it happened.
Okay.
I was there.
You were there.
Yes.
Okay. Is that something is it a joke? Do you find it funny?
What are you asking? Find what?
Is being kicked in the groin funny?
What's the relevancy of that question?
Just a general question, Your Honor.
No. No, he's not going to answer that. You're not answering that question, man.
Okay. I'm trying. When the ambulance showed up, did you report these injuries to them?
Your Honor, object that the witness has said repeatedly that he was kicked. I don't think he's ever said he was injured.
We're here on an assault charge, Your Honor.
An injury is not necessary to prove an assault.
I know.
I know you do. I'm just making the record. Excuse me, Your Honor, I apologize.
No, it's okay. I got it. So what is your question?
Did you
Did you
report
receive
these?
medical attention for being kicked?
No, sir.
All right, very good. Go on, move on.
Did you at any point tell any medical professional?
Your Honor, object.
That would be medical attention.
No, not if.
Yes, it would be, because he would have to report it for it to happen.
Okay.
He's answered that question. Next question.
I just want to play this moment here. This is same camera.
I'm sorry, Your Honor. This appears to be in a medical.
What is this? What am I going to watch? Give me a
This-
proffer.
What is it? Give you what?
Tell me what I'm going to see.
You're going to see Officer Tyson confess that he was joking about what he said
About what he said about what?
about me striking him.
Okay. Let's see.
Let me drink it, man. It's the one at the bottom. Yeah, I've seen. About 2191, that's his phone number. Yes, sir, that's just my way of not having a 734. What's up? Check before.
Wait, Your Honor, can we pause, please?
Pause it.
Your Honor, this is information not relevant to this defendant. This is a separate person's name and date of birth now that's being put out, is not relevant to this. He has privacy rights that I did not play any portion of the video revolving him specifically to respect his rights and not be a part of this. He doesn't have to be. So I'm objecting to the playing of this. If we could get to the point of whatever the defendant is trying to put before the court, I'd really appreciate it.
It's coming right here, Your Honor.
Well,
And I would argue that Jacob Spaulding would be a key central figure since he's the reason I was detained in the first place.
yes, but that doesn't mean he's giving consent to have all of his stuff put out there. What are you? So
This is a pivotal moment. The defendant attempt to introduce what he claims is a certified transcript suggesting that an officer admitted to joking. But here's the procedural issue. It wasn't disclosed to the prosecution beforehand. In court, surprise evidence rarely lands well, especially without proper foundation or prior submission. Notice the judge's tone shift here. This isn't about the substance of the claim yet. It's about courtroom control and rule compliance. When a defendant interrupts or attempts to speak over the court, credibility can quietly erode. Judges weigh demeanor just as heavily as testimony. Legally speaking, resisting and obstructing does not require proof of injury. That clarification earlier was critical. The core issue is whether lawful commands were given and disobeyed. Here's the engagement question.
So where's the part about him joking?
He quite literally says it, Your Honor. And I have certified records that have been transcribed from a
Certified by whom?
by a certified Michigan court transcriber, but nevertheless, he's.
Well, if you're
he's present.
saying you have something that says that, because I did not hear that. So if you say have something that says, no, do not play over me when I'm talking. Stop.
I'm sorry.
Cut him off. No, we're not doing it that way, Mr. Magoo. You're playing by this court's rules. Plain and simple.
I'm trying to.
No, you're not. You're trying to play by your own rules.
Oh.
And it's not gonna, do not shake your head at me because it's not gonna happen. I'm letting you know that now. Now, if you're claiming you have some certified transcript, where is it? And has it been turned over to the people?
It'll be submitted after I have a digital copy of it.
Have you submitted it to the people before
I
today?
just got it. No, I just got it. Same videos I had.
I don't even know how you're gonna, I don't even know how that gets in, but I'm not even gonna worry about that at this point. Go
Did you
ahead.
hear what was said?
Continue with your questioning.
Did you hear the part where you said you were just joking? What did you say? You told the ambulance that you were kicked in the nuts?
Yes.
And then what? Laughing? And at that time, in between that point where you said you got kicked in the nuts and you started laughing, did you hear the part where you said, "I'm just joking, haha, you got to deal with me for the rest of the night"? Okay. I'll be wrapping up right here. I just want to clarify. In your opinion, what justified the search and detainment of me that day?
Because you were resisting and obstructing. He gave you directives to walk away. You did not.
To the gentleman that went away in the vehicle. Of obstruction. I was obstructing your medical evaluation. Because you at no point, you admitted that you had no point to plan on charging him with a crime. You guys were doing a great thing out there. You guys were helping him out. You guys are making sure.
Is there a question?
I'm trying to clarify.
No, is there a question?
Yeah. At what point do your medical evaluation supersedes my personal rights to public space?
I'm objecting.
Hey.
That's the relevance.
Yeah, the form of the question, and that calls for a legal conclusion. So I'm going to sustain the objection.
Is there any witnesses? Did you guys get any witnesses on the scene
To what?
to all these crimes that I'm charged with? Is there anybody else on the scene that you guys talked to that put me on any kind of crime?
I understand your question.
What crime do you think I'm guilty of?
Oh my gosh. Objection.
Sustained.
I don't speak legalese, Your Honor. I'm really trying over here.
Again, I don't need your satire. Just next question.
You said that you reviewed these tapes beforehand? These videos? Did you at all review that part of you speaking with the ambulance when they arrived? Did you at any time read me my Miranda rights? Before your arrest, you did not read me my Miranda rights.
I've never heard you know, if I'm gonna ask you questions. I have questions about anything.
Okay. No more questions, Your Honor.
Any redirect?
No, Your Honor, this one speaks to you.
Yeah, all right, your excuse, sir. Thank you.
Yes, sir.
How many more witnesses do you have, Miss Lundy?
One.
One? Okay, I'm gonna take about a 10-minute break because I'm gonna need it, and then you can call your next witness. Court's gonna stand in recess.
All rise.
Additional witnesses, people rest.
All right. Any witnesses for the defense?
No, Your Honor.
All right. Do you have a motion?
Yes, Your Honor, at this time people move for bind over on the single count of assaulting, resisting, or obstructing Darnell Tyson. Will reserve any further argument for rebuttal.
Respond. The sergeant's name was Sergeant Griggs, wasn't it?
Gibbs, G-I-B-B, both is in Lloyd S.
Yeah.
But, why are we not hearing the testimony of the other witnesses?
I'm sorry?
I was asking why we're not hearing the testimony of the other witnesses.
Because neither one of the parties called them.
I would like to call them, Your Honor.
Any objection to reopening the proofs?
Your Honor, I will let the court know, part of the reason I changed my mind is because I failed to instruct the officers who were in the hallway that they could not watch the proceedings on YouTube. So it's my understanding they did watch the testimony of Officer Tyson on YouTube, and I apologize for that. Didn't intend to have that happen. I deeply am regretful of that. I did not know what was going on until I went out in the hallway. Didn't intend to call them because their sequestration had been broken and rest on the proofs that were proof for the court.
Still wish to call them?
Yeah,
Yes?
yes, I do, Your Honor.
Are they still here?
I believe so. Which one?
Which one do you want, sir?
Both of them.
Both of them. Great. Just bring everybody back.
Sounds great.
Okay. So which one do you want to call, Mr. Magoo?
Start with Officer Smith.
All right. Officer Smith, did you want the other officer? Did you want the sergeant? Did you want the sergeant sequestered during this testimony or?
Yes. No, you do.
No, you don't give orders. You just don't.
Sorry.
You just don't. No, you don't.
It was a request.
No, it doesn't matter. Yeah, keep smiling. That won't end well. Let's have him so.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth.
Okay, sir.
Yeah, see, state your first and last name for the record, please.
First name is Lawrence, LAWRENCE. Last name is Smith, SMITH.
You may inquire.
Oh, they don't start at all. Because they don't want.
It's your witness.
Right. How you doing, Officer Smith? You have to lay a foundation with, since we all know where we're at on the night. Where were you in the October 11th, 2:50 in the morning, and what brought you to there?
Objection compound.
Okay.
Sustained. Ask your question.
What led you to a parking lot in Ypsilanti on October 11th, 2024, at 2:50 in the morning, approximately?
We were dispatched to a fight progress.
Fight in progress.
Yes.
Did you get a description of the people in the fight?
Upper Metro East did.
What was the description? Do you remember? Oh. You were just looking for 2 people, or how many people? Don't recall. Okay. Do you recall the ethnicity of the people that were called? Were they what the dispatch? Who was the dispatched over the fight? I believe they gave some descriptive words in the police report. And do you recall what the do you recall any descriptive words that would characterize the people that you were looking for on October 11th? What led you to approach me?
Well, we seen an individual sitting, I believe, slumped over and looking non-responsive at the point, and we've seen alcoholic beverages around the individual, so we assumed it was high touch. So at that point, it's our job and duty to end up rendering aid to the individual, and then having the ambulance come and assess their medical needs at that point.
Okay. You assessed that another individual was highly intoxicated?
Yes, these are our observations.
At this stage, the prosecution moves for a bind over on the single count of assaulting, resisting, or obstructing. That means the court must decide whether probable cause exists to advance this charge further. What we've seen throughout this hearing is a clash of perspectives. The defendant challenging justification and procedure, and the officers maintaining that commands were given during a response to a fight call and were not followed. The judge's rulings consistently emphasize courtroom procedure, evidentiary standards, and the legal definition of obstruction. Emotional exchanges, objections, and questions about Miranda rights all surfaced. But the legal threshold here centers on lawful command and refusal. This hearing underscores how quickly roadside encounters can evolve into formal charges when compliance becomes disputed. If you found this case as intense as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.